Major breaking news. The U.S. Court of Appeals for the Fourth Circuit out of Richmond, Virginia, and Maryland has just found that federal gun control law 18 U.S.C. 922 G4, dealing with those who have been incapacitated or incarcerated or civilly committed due to mental illnesses, can indeed lose their Second Amendment rights for at least some period of time. We're going to break down this decision by the Fourth Circuit just now. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, we have a decision here in the United States of America versus James Gould out of the U.S. Court of Appeals for the Fourth Circuit there in Richmond, Virginia, and the state of Maryland. This was a challenge to the constitutionality of federal gun control law 18 U.S.C. 922 G4, which deals with possession of a firearm after having been previously committed involuntarily to a mental institution. The claim here by Mr. Gould was that his Second Amendment rights were being violated when he was indicted and convicted of possessing a shotgun after he had been civilly committed to a mental institution. He brought a facial challenge, and this is important, folks, to understand this. He brought a facial challenge to 18 U.S.C. 922 G4, claiming that this law facially violated the Second Amendment. He did not apparently raise issues as applied to him or to specific people. He just said that the law on its face is unconstitutional in all of its applications. Well, this was always going to be a stretch of an argument in my view, because I think it is likely the case, and the Fourth Circuit agreed with this, that there are going to be at least some instances where people have been civilly committed to mental institutions because they are viewed as a violent danger to themselves or to others by virtue of a mental defect, a mental disease, psychosis, schizophrenia, whatever it might be. And the Fourth Circuit today agreed with that assessment, saying that Mr. Gould's facial challenge to this federal gun control law failed. It failed. And what the Fourth Circuit basically said is, if you look at the Rahimi case, which we've talked about extensively, if you look at the Rahimi case, this particular statute satisfies what Rahimi said, which, as you may recall, Mr. Rahimi was a bad dude, engaged in multiple shootings, and admitted in court and in writing that he had beat up his girlfriend or ex-girlfriend at the time and was a danger to her, and agreed to a restraining order, not being able to touch guns and or to get close to the girlfriend or ex-girlfriend. That was Mr. Rahimi's case. And the Supreme Court said that the federal gun control law that prevented him from possessing firearms was constitutional, because, number one, there was a finding by an objective court, a finding that Mr. Rahimi was a violent danger to others, i.e. to his girlfriend. And here, the Fourth Circuit said, by analogy, there are going to be instances where an individual is adjudicated to be a violent danger to himself or to others by virtue of a mental illness, maybe schizophrenia, maybe psychosis, whatever it might be. Could be a deep depression. No way to know. But the point is, there are at least some situations where an individual, by virtue of the cause of a mental illness or mental defect, whatever you want to call it, could be dangerous to himself or to others. And thus, like in Rahimi, those individuals, if they are found to have been a danger by virtue of a court, whether it be Mr. Rahimi in the context of a violent crime, or in the case of Mr. Gould, apparently, a determination that he was a violent danger because of a mental illness. And again, usually the reason why you're involuntarily civilly committed to a mental institution is because a court has made a determination based on the evidence that you pose a danger to yourself and to others, and as a consequence, they put you into a mental institution to protect you from yourself and to protect others until you are fixed, rehabilitated, cured, whatever it might be, and no longer pose a threat to yourself and to others, at which point, in theory at least, you are released. So again, there was a finding here apparently that he needed to be civilly committed, Mr. Gould here, and therefore the Fourth Circuit here says, well, there's a finding, and he was civilly committed. Now, it then goes on to point out, in addition to the fact there was a finding by a court and a finding that he was dangerous, it goes on to say that there is historical precedent for protecting people from these dangerous people. And that is exactly what the Supreme Court said in Rahimi, which you have two sets of historical laws at the time of the founding that do say that citizens can use government actions to protect themselves from violent people who have guns. The first set are the surety laws that basically said if there's a finding of fact at the time of the founding that you pose a danger to your neighbor or to somebody else, you can be forced to pose a surety or to get sureties or some other method to prevent you from engaging in violent crime that you are likely to engage in the future based upon a finding by a court. It's not just willy-nilly assertions. There has to be a finding at the time of the founding under the surety laws. And again, here in the Gould case, the Fourth Circuit relied upon those, saying there's a historical tradition of people being disarmed or otherwise having to pose sureties if they are found by a court to be dangerous to themselves or others. Then they go on, and this is the same body of law that the U.S. Supreme Court also used in Rahimi to uphold the conviction of Mr. Rahimi, and that was specifically that there are these so-called affray laws, which basically says that people that use firearms in public to go around to the terror of the people, which means basically you take your gun and you threaten people and you scare people with your weapon or arm or whatever it is, that you can go to prison. That's a crime. That was a crime at the time of the founding. You could not take your gun out and threaten people and terrorize people. That was a crime. So here what the Fourth Circuit said is, like the Supreme Court said in Rahimi, the Fourth Circuit in Gould said today, that look, if you look at the affray laws that say people cannot terrorize people with guns, which means you can be imprisoned, and likewise, if somebody who is found to be a danger to themselves or to the others may have to post a surety. With those historical traditions at the time of the founding, the principle is that we as a society can take certain steps to prevent individuals from possessing firearms and disarming them if we think they are a danger to society and there's been some sort of an adjudication of the same. Right? Because you go to prison for violating the affray laws at the time of the founding because a jury finds that you were a danger, you were terrorizing the public, and you can go to prison for that. And likewise, when it comes to the sureties, there has to be a finding by a court. So the central feature to all of this, as the court in the Fourth Circuit pointed out today, is there has to be a finding by a court. This is not just your neighbor, alleging that you're a Trump supporter or something. No, there has to be a finding by a court after due process that you're a danger to yourself or to others. And if that occurs, then you can be disarmed. And what happens here in this Fourth Circuit case of Gould is they said, look, Mr. Gould was civilly committed involuntarily, to a mental institution. He never sought to restore his rights, either at the federal level, which was not available to him due to funding issues, or at the state level. That didn't happen. And as a consequence, he was found to be a danger because he was civilly committed involuntarily. And then later on, he possessed a firearm. He never restored his rights. Had he restored his rights, maybe something would have been different. But anyway, the court here did not get specific to Mr. Gould. And the reason why they didn't get specific to Mr. Gould's personal situation is the court said, look, this is a facial challenge to the statute, and a facial challenge, which is different than an as-applied challenge, is basically saying that there's no constitutional application consistent with the Second Amendment for this particular statute. But because you have the possibility of this federal statute preventing people who have been civilly committed to mental institutions from being denied the ability to possess firearms, because there are instances of violent, dangerous nut jobs who have been civilly committed and should be denied access to guns. As a consequence, they say that there is at least going to be some instances where this particular federal law can be constitutionally applied consistent with the Second Amendment. And at the very end, this is significant, folks. Listen carefully. This is hugely important because the Fourth Circuit said, look, even though we're saying facially this law is constitutional, because there's some constitutional applications of it, we are holding open our opinion as to whether or not specific people in the Fourth Circuit in Virginia, Maryland, and the like, whether or not they can get their gun rights back and their rights have been violated by the Second Amendment under this law if they're not a danger to themselves or to others today. Maybe, just maybe, this particular law would be unconstitutional as applied to those particular people. But again, Mr. Gould made a facial challenge and not an as applied one. Just to jog your memory, you may recall in the U.S. Court of Appeals for the Third Circuit, in the case of Brian Range, that was an as-applied challenge to a different part of 18 U.S.C. 922G. That was 922G1, felons in possession, because Brian Range said, look, I was convicted of a misdemeanor in Pennsylvania for a food stamp crime 30 years ago, and there was never a finding that I was even dangerous. And it was very focused on his personal situation. And the Third Circuit en banc ruled in favor of Mr. Range in a huge way. But in contrast, Mr. Gould here brought a facial challenge as opposed to arguing about his specific issue. He said, no, it has applied challenge. He brought a facial challenge. And the Fourth Circuit really laser focused and made this point at the end of their opinion, saying we're holding out the option of people bringing as applied challenges under the Second Amendment to this particular gun control law. Specifically, the court wrote, we want to emphasize the narrowness of our holding. Disarmament under 922G4 is facially constitutional because situations exist where it may be applied consistent with the Second Amendment. Think about Michael Myers in Halloween. That would be an example of a guy that this law would apply to, obviously, to Michael Myers in the Halloween movies. It would apply constitutionally to him because he was found to be a danger to others and so on. It was an amendable institution. That's an example of this law being constitutionally applied in a particular case. But again, the court goes on, and this is very important. Listen carefully to this. The last sentence of this opinion of U.S. versus Gould for the Fourth Circuit is important and very good for the Second Amendment. This is what they write. We express no opinion on as applied challenges to the statute. What they're basically saying is, don't come at us with a facial challenge ever again, because it's clear that the statute as applied to certain people, like the fictional character Michael Myers in the Halloween movies, would be an example of it. And there are other people that are in mental institutions, involuntarily civilly committed because they are indeed a violent danger to themselves and to others. They can be disarmed under federal law, consistent with the American tradition of firearms regulation. However, there may be instances where this particular statute is applied to a particular person in an unconstitutional way. And if that occurs, then we in the Fourth Circuit Court of Appeals are going to be saying, no can do. That violates the Second Amendment with respect to that particular defendant, that particular person. So again, with that said, now, this all ties in to what the Trump administration is doing, which I totally support and you should totally support too. And that is that Pam Bondi and Donald Trump and the Department of Justice are putting together that robust restoration of rights program where the Attorney General has the authority, which she already does under the statutes of federal law, to restore the rights of individuals who perhaps are convicted of some crime in the past or maybe even involuntarily committed in the past to a mental institution, but can now have their rights restored because today they're no longer a danger to themselves or to others. And that's why these kinds of opinions we're seeing out of the Court of Appeals, like this Gould opinion today, are blending in and conflating and working together with, if you think about it, with what the Trump administration is doing to expand the right and really to restore the right to keep and bear arms with that restoration of rights program. So that's why we have to talk about all these things together. And again, the trend remains our friend, notwithstanding the fact this is a very narrow ruling technically against the Second Amendment. But frankly, this is probably the same opinion I would have written if I were on the Fourth Circuit, because again, at a facial level, at a facial challenge level, those are often relatively easy for the government to succeed on, especially with a situation where it's just saying that if you're a violent danger to yourself because of mental illness, you can be disarmed temporarily after a finding. That is something that I don't think you're going to see too many people on the other side of in the real world. So I'm not that upset about losing this particular Second Amendment challenge because I think that's probably the right answer by virtue of how this was argued. And there's lots of room for maneuvering for specific individuals to get their rights back and to find that this law as applied to them is unconstitutional. So I'm not going to lose a lot of sleep about this particular Second Amendment loss in the Fourth Circuit today. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both to the both here at the 4Boxes Diner on YouTube and the 4Boxes Diner on Rumble. And I look forward to talking to all of you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.